Hello everybody, I am Anu Priya and today we will be dealing with Hindu Succession Act. I am Assistant Professor in Rai University and we will be dealing with the family law 2 part, that is for semester 4. So before starting with this section, we have to understand two things very carefully, that Hindu Succession Act is basically about the intestate person. What is intestate means? That if a person dies without making any will, without making a previous allotment that my property will belong to somebody else, that particular person. So if there is no will, there is no testimony at all, no instrument, then we will deal with it about the Hindu Succession Act, and that particular person who dies intestate should be Hindu. So in this section, in this lecture series, we will also understand that who will be called as Hindu as per the Hindu Succession Act as well. So let's start with the applicability of Hindu Succession Act. So at first you have to learn that section 2 of Hindu Succession Act basically deals with the applicability part of the Hindu Succession Act. In this section we have noted that the act shall extend to whole of India. There is no such exception at all that it will apply to that particular territory. It will apply to the full extent to the whole territory of India. Any person who is Hindu by religion or any form of development, including a Vaishnav, Virashava, Lingat, or a followers of Brahmo, Pratna or Arya Samaj. So all these religions who are developed from these particular groups by religion, they will be called as Hindu in this act. And other is any person who is a Buddhist, Jain or Sikh by religion. So anyone who follows or adopt the path of Buddhism or Jain or Sikh, everyone will be considered as Hindu as per this law, and this act will be applicable to that particular religion as well. Any other person who is not a Muslim, Christian, Parsi, Jewish. So any other, by this section, this actually broaden the scope of the term Hindu so that the act will be applicable to the person who does not come under these sects as well. So if there is any other religion group as well, who is not Muslim basically, Christian, Parsi, Jewish, then that person will also consider as Hindu. Proof that unless it is proved that such person would not be governed by Hindu law. So if there is some other custom and that person prove by itself, the burden of proof will be in that person that he is not governed by Hindu law. There is particular custom by which they are actually ruled with. In that case only there will be an exception, otherwise there will be no such exception. The act shall not apply to the member of any scheduled tribe. So Article 366 clause 25 give an exception to scheduled caste, scheduled tribe basically, ST caste, scheduled tribe. So the member of the scheduled tribe are pardoned or are in the exception. They will deal with by their religious things, and the Hindu Succession Act will not applicable to that particular group. Next is, who person is qualified to be Hindus? Who will be called as Hindu? We have already read that what particular people will be called as Hindu. Buddhist, Jain, Sikh, other than Muslim, Farsi, Christian, they will be called as Hindus. So some more details about is that any legitimate or illegitimate, it is irrespective that child is legitimate child or illegitimate child. If both parents are Hindu, Buddhism, Jain or Sikh, then by birth that child will become Hindu child. Another is any legitimate, illegitimate child, one of whose parent is Hindu. If any one of the parent is also Hindu, Buddhist, Jain or Sikh, then that particular child will be also considered as Hindu. And who is brought up as a member of a tribe, community, group or family by which such parent belongs to or belong. If that child is also adopted, in that case also that child will be considered as Hindu. Next is a person who is converted or reconverted to Hindu, Buddhist, Jain or Sikh by religion, that person will also considered as Hindu. So if any person is converted or reconverted, then that person is also considered as Hindu. Next slide. Important terms relating to Hindu succession. So these are some important terms we will reading by stepping out in the provisions. So we have to understand these terminologies at first so that we will not have face any problem while proceeding with the provisions of the Hindu Succession Act. The first is agnet. What the term agnet basically means is that a person is said to be an agnet to another if the two are related by birth or adoption wholly through male line. If there is male line, the transaction of the property or of an intestate are actually transferring by the male line only, male person only, then that will be considered, that line will be considered as agnet line. Then other is cognate. If it is not wholly through male, there might be some female in between, then that will be considered as cognate. Next is higher. Who will be higher? Higher are basically any male or female person who is entitled to receive the property of the intestate according to the provisions of Hindu Succession Act. So if any person who is entitled, legally entitled to inherit the property or entitled to receive the property of a person who dies in intestate or does not made any will or instrument or testamentary, in that case that person will be considered as higher. What will be the example of higher? Example of higher maybe descendant of the particular person. For example, if a father dies, the property will belong to son. So son will be the descendant of the father and he might be the higher as well. Intestate. According to section 3, subclause 1, subclause G, a person who dies without leaving behind a will or referred to as intestate. We have discussed about the intestate, a person who has not made any will, who does not transfer his property by making the will and dies without making any will, that person will be considered as intestate. Next is related. A person can be related by blood or by legitimate or illegitimate as well, but the illegitimate child are deemed to be related by the mother only, and legitimate child were deemed to be related by full blood. So basically the relationship between the kin. What is kin? Kin is about relatives. So if a person is related to one person to another, the related word basically means there is some bond, there is some kind of full blood, half blood, or uterine relationship between the two person is, then there will be a term of related. Next is there are various types of succession. Basically that is testamentary succession or intestate succession. So the term testamentary succession basically means then if a property transfer by making a will or in testament, then that succession will be considered as testamentary succession. But in this law, this law basically focus on is based on intestate succession. If a person does not make any will and the property is how the property will dissolve among the heirs of that intestate person, then that is actually intestate succession, and this is what we will deal in this act. So next is section 8. So section 8 basically deals with general rule of succession in Hindus. What are the general rule of succession? Very simple. If there is actually mentioned some classes, class 1, class 2, agnet, then cognate. This is what the process of property flows. At first case, the property will transfer to the class 1 higher. If there is no person in class 1, then class 2. If there is no one in class 2, then agnet. If there is no one in agnet, then cognate. What basically class 1 basically means, you have to refer this diagram for this. This is the diagram for class 1 heirs. Who are the people, who are the relatives which are under the class 1 heirs after the amendment of 2005. So if a person deceased, for example, M is a person who is deceased, died intestate. So the class 1 heirs are W, that is widow, then S, son, D, daughter. So if a person deceased, his son, his daughter, his widow, then son's widow and son's daughter, then daughter's son, both. Then the third generation is also covered. You have to learn this basically. So this is a class 1 chart. So the property first dissolved to class 1 heirs. Then it transferred to class 2 heirs. These are the list of class 2 heirs. You can find all this list in the Hindu Succession Act in the schedule past. as soon as the provision section will end, there is a schedule part and you can find it over there. Next is section 9. So we have read that the property will flow from class 1, then class 2, then agnate to then cognate. What will be the order? The order will be among the highest specified in schedule, those in class 1 shall take simultaneously. So the property which are transferred to class 1 higher, so every people who comes under the class 1 higher will take the property simultaneously. Each one share to each one person. So let us understand from this graph only. So if a person died, the one share of the property will go to the widow, the one share will go to the son, one share will go to the daughter. Simultaneously the property will divide, equal share in equal share. Then if a person, maybe the daughter is deceased, so pre-deceased daughter, in that case the one share which belongs to daughter, she is no more, she is pre-deceased, then that one share will equally in the equal portion divide to their heirs, that is daughter's son or daughter's daughter. And in the same, the process will be similar in the son's case as well. So next is, the difference is that daughter's husband does not get the property from the deceased person, intestate person, but the son's widow gets what? Gets receive. So in this section, you can see among the highest specified in the schedule, those in class 1 shall take simultaneously. So the property will simultaneously in the shares divide to everyone who belongs to the class 1 higher. Then, and the exclusion of all other hires, so the class 1 or agnate or cognate will be excluded. Those in the first entry in the class 2 shall be preferred to those in the second entry. If there is no one in the class 1 higher, then the property will pass on to the class 2 higher as per section 8 of the Hindu Succession Act. In that case, in case of class 2 higher, what will actually happen? That at first the property will go to father. In the first list, whoever in the first list, first entry will go to that person at first. If there is no one in the first entry, then it will transfer to the second entry. If there is no one in the second entry, then to third entry. This is what this section is dealing with. Those in the second entry shall be preferred to those in the third entry, and so on in succession. So this is the order of succession which we have dealt in section 9 of the Hindu Succession Act. Section 10. Distribution of property among higher in class 1 of the schedule. So we have already read about it. So now we will see it in the section 10, that how the share is simultaneously divided in the class 1 highest. So this is how. The property of intestate shall be divided among the higher in class 1 of the schedule in accordance with the following rules. Rule 1. What is rule 1? The intestate widow, or if there are more widows than one, all widows together shall take one share. So if there is one widow, she will take the one share. If there are more than one widows, all together will take one share out of the property. Second is the surviving son or daughter and the mother of the intestate shall take one share. So there is a difference between mother and widow. A person might have two wives, so the mother of the surviving son and daughter are considered as mother. The surviving son and daughter and the mother of the intestate shall take one share. So if a person A died, so in that case the widow will take one share. If there is more than one widow, then all widows will take one share. If there is mother of the intestate, then mother will take one share. And if there is son and daughter, that all sons and all daughters will simultaneously take, each one will take one share in that particular property. Then rule 3. The heirs in the branch of each predeceased son or each predeceased daughter of the intestate shall take between them one share. So if the son is there and the son died, so that son will be considered as predeceased son, and in the same applies to daughter. If there is a daughter and heirs of daughter are there and the daughter died, So that daughter will be considered as predeceased daughter, and that predeceased daughter and predeceased son will also be granted one share, and that one share will simultaneously divided into the heirs of that particular predeceased son or daughter. Next is Rule 4. The distribution of the share referred in Rule 3 among the heirs in the branch of predeceased son shall be so made that his widow or widows together and surviving son and daughters each get each equal portion. So if there is predeceased son, that one share will belong to the predeceased son, and that one share will considered as whole of the property, and that one share how it will be divided, that in that property the widow of that predeceased son will take one share, and daughter and son will take one share, in such a way that the property will divide equally among all of them. Next is, and the branch of his predeceased son get the same portion, and if there is some sons, predeceased sons have a predeceased son, then that son will also get one share like a equal, as if that he was also a surviving son of predeceased son. Next is, among the higher in the branch of the predeceased daughter shall be so made that surviving son and daughter get equal portion. So the transaction will be such that all the surviving son and daughter will get equal portion from the property. So this is all for the Hindu Succession Act overall here. We will continue in the next lecture. Thank you for your time.